Welcome everyone to this Pacific Justice Institute Zoom call, where we're going to take a look at some major Supreme Court decisions that will have a definite impact on religious freedom for both employees as well as for employers and businesses. So I think this is going to be very interesting. You know, in the news, we discovered that they were talking about these cases very narrowly, and really weren't talking about the breadth of it, or they were applying it too broadly and flippantly in the wrong direction. It's the kind of decisions that I dream about. Last year, as many of you know, we saw some great victories from the Supreme Court. The Dobbs decision, which was fantastic. It was reversal of Roe versus Wade. I would have given my life to have that outcome. We had decisions from the court upholding school vouchers, the constitutionality of that to move forward. Now it's exploding. That was another biggie. And now we have two big cases in particular that came down this year, just recently from the Supreme Court, that have a big impact on religious freedom. So last year, it was sanctity of human life and parental rights over their children's education. This year, it's religious freedom for employees, as well as religious freedom for business owners and senior management. So we're going to talk about those today. First, I want to give you some brief updates, some good news. We've got someone new coming on board. It's going to be our new legislative council. That's right, legislative council. And they're going to be starting next month. And they're going to be working with our different regional offices. We have 31 offices across the country. They're going to be working with those offices to help put together legislation through our Center for Public Policy division, and it's going to deal with issues of parents' rights, religious freedom, sanctity of human life. It's going to be very powerful, and she's going to be playing an active role in helping our attorneys in these different states be able to testify and support solid legislation. We're seeing great progress, unbelievable progress in the red states like never before, partly because of these Supreme Court decisions that have come down recently over the last 2-3 years. Well, we're going to try to make the most of it. So this is a new venture that we're very excited about. We also are going to want to give you some updates. If you'd like to receive updates, text updates, or email updates regarding our cases, we have over 180 cases in active litigation coast to coast. Where it's exploding. If you'd like to keep up with that, just simply text PJI. PJI stands for Pacific Justice Institute. Just text that to the numbers 71541. And I remember that as a 71-year-old man having lunch with a 54-year-old woman and as a 1-year-old in the high chair. It works for me. That's all I can say. So 71541. And you can get our information. And you're not going to hear this from major mainline media, our cases in litigation. But we're all over the country. We've got, I think, the largest footprint of its kind in terms of our offices, our litigation. I think you'll find it very encouraging moving forward and empowering. And then finally, we have our Celebration of Justice event coming up. It's going to be on October the 28th at the JW Marriott. We have Kayleigh McEnany, former White House press secretary. She's going to be there, and she's going to be moving on to testify, not testify, she's going to be speaking. And that's going to be a wonderful event moving forward. And so I think that could be something you definitely want to check out. I just want to be honest with you, though, right up front. I've already, it looks like we have, the overwhelming majority of our tickets are already sold. We have over 500 tickets sold or tables reserved. So we are already well past the majority. And so if you want to go attend, if you want to sponsor a table, if you want to be a corporate sponsor, we really push out and promote companies that are corporate sponsors in some really beneficial ways. Just go to our website, pji.org, and participate. That'd be great. Now I'd like to go ahead and open us up in prayer. Father, we thank you for this opportunity to get together, and thank you for the grace that you give us in our courts. It reminds me, Lord, of the book of Esther, how even though things were evil, how you turned things around through Mordecai and re-empower the people of Israel, not just to be defended, but to go on the offense. And in the same way, I see the same opportunities taking place now, Father. Let us be faithful. Let us be faithful with what you've given us and understand the significance of what you've given us by your grace through these modern-day Mordecais sitting on the Supreme Court. We thank you and just guide this whole time for your glory. In Jesus' name, amen. I'd now like to bring on the program Peter Mord. He's a pastor of a church. He's also the head of our church engagement office. It's an exciting office that is making a big impact in terms of empowering people to vote and empowering churches to have their voice heard. Peter, are you there? Can you give us a brief update on what's taking place right now in your neck of the woods and your division of Pacific Justice Institute?
Absolutely, Brad. We are excited about the next 18 months of encouraging churches to find their voice and to encourage their members of their church to vote their values and to get involved. They no longer can stay in the middle, stay neutral. The devil owns the fence. We want to get off the fence. We want to be salt and light in this dark day. And we're helping to train churches on how to do voter registration and encourage people to be involved in elections and election integrity.
Now, we've expanded well outside of California and a number of other states. What's going on there? How's that working?
Yeah, a lot of people don't know that a Senate race in Nevada was only decided by a few thousand votes. And we believe that Nevada and Arizona, which are swing states, are an important focus. We've been meeting with pastors and encouraging them to do what they can do. And we saw the governorship change, and some big changes have happened in Nevada. Also in Arizona, there have been some massive shifts, and we believe that God's at work, and we just want to do what we can do and leave the rest to him.
That's right. And at the end of the day, we should be faithful with what he's given us to be faithful with, and then at the same time be restful knowing that he is God, and he hears our prayers and is working and raises up and brings down. So I appreciate that. Folks, if your church hasn't done a church voter registration Sunday yet, I strongly encourage you to contact Peter. He can make it very easy for your church. If your church is a Bible-believing church and has a biblical worldview, we can take care of the rest. Just contact Peter Mord, and we'll be happy to work with you and your church to get the football down the field and allow their church voice to be heard this upcoming election in 2024. Peter, thank you so much for what you're doing and the Church Finds Its Voice program to help empower churches and keep up the great work. We're getting recruiting. Real quick, one last question, Peter. How many churches do we have personal relationships with that your church has nurtured and provided relationships with?
You know, we've seen about 1,200 churches get off the bench and in the game, and we're looking for more churches. If your church wants to be active in their community and not just us four and no more, but getting out and knowing who your elected officials are and actually influencing them with kingdom values, man, we'd love for you to join that effort.
Right, and you've got staff that we have at PGI in our church engagement office along with you. So folks, don't hesitate, get involved. If your church doesn't do voter registration Sundays, they've never done one or they don't know how, we make it easy. And if your church is like, no, we don't want to get involved in anything that's political, I mean, I just find that so unbiblical and so uncaring. A church that's filled with the love of Jesus is a church that's going to care about people outside their church walls. And if a church truly cares about people outside the church walls, they're going to vote. Voting is a manifestation of the fact that you care. So we're here to serve you and serve your church, and I encourage you to do that. If you're part of a church that isn't wanting to talk about the issues as applied to God's word, and God's word is there to apply to the issues of the day, if there's someone who avoids that, etc., is just wanting for everyone to feel good, you might want to think about a different church that actually preaches and applies the word of God. And part of that application is for us to be good citizens and to not to hesitate to manifest the love of Christ in every way we can to a world that needs it. So thank you very much, Peter. Appreciate that. And now we'll move on to the cases that we talked about. The first case I want to talk about is Groff versus USPS. This is a case dealing with a postal worker. Kevin Snider is our chief counsel. Kevin, can you talk about this postal worker at wanted to have Sunday off and wasn't allowed to?
Yeah, Brad, I'd be glad to. As you mentioned, there was a postal worker, evangelical Christian. He applied for and received a job with the post office. And for him, his beliefs are that Sunday is his day of rest and worship. And so he asked his employer, the Postal Service, to let him have those days off. And they agreed. Well, as time went on, the Postal Service contracted with Amazon and started delivering on Sundays. So this postal worker, Mr. Groff, decided he would ask for a transfer to a rural postal station, post office, and it was granted. And that satisfied him for some years. Did not have Sunday deliveries, but as Amazon grew, so grew the need for postal deliveries on Sundays, and it finally reached the rural areas, and they were scheduling him for Sundays. And so Mr. Groff asked to have those off, and they tried to. There was another employee who complained about that, and so they said they couldn't accommodate him for his Sabbath accommodation. And so he was forced to resign. So this matter went to the courts, and that sets the stage for what happened.
Okay. So he went to court, and basically I understand, the issue with the court was what is a reasonable accommodation, and whether the employer is required to. And the case law, or the law, says that they have to reasonably accommodate people of faith with religious objections in the workplace, absent an undue burden or hardship. So in the past, Kevin, the courts for the last decades, they've sort of watered down that language and said, well, an undue burden or hardship is just something that's more than just a de minimis loss, something that's just more than just an inconvenience. And if an employer can show that, they don't have to accommodate the person of faith. But this Supreme Court looked at that a little differently, didn't they?
Yes. So for several decades, a lot of courts across the country, based on a one line in a Supreme Court case, said that if there's any kind of de minimis or insignificant cost imposed on the employer, then they don't have to accommodate the employee. And so that meant that essentially employees generally would lose their cases, their requests for religious accommodation, because it could be any minor inconvenience. Right. Well, as you mentioned, the law actually doesn't use the word de minimis. It uses the word undue hardship. So what does that mean? And that was the question that the court faced.
Yeah. Now, Emily, my understanding is that the court, they threw out de minimis and said, that's not what was intended. What did they replace it with? What does an employer have to show in order to not accommodate someone of faith with a religious objection in the workplace?
Right. The de minimis standard, as you said, is out. And just as a side note, I would say whenever lawyers or courts start quoting Latin at you, be suspicious. So the de minimis standard is out, and replacing it is this standard, which is a substantial burden. Okay. And okay, what does substantial mean? And the court kind of said, we're going to leave that to the facts and circumstances of the case. But what's important is undue hardship means what it says. And so undue hardship. So some hardship is required and expected as an accommodation. And so remember, you can't say, oh, it's a hardship. Well, no, it's an undue hardship in the context of the specific business in which the employer is engaged. So de minimis is out, substantial is in, and you need to look at the facts and circumstances. You can't just say, oh, it's a hardship, I'm not going to accommodate your religious beliefs. Yeah,
so they've got to look at, I think the word substantial costs or substantial expenses, I think was in there as well. So it's really beefed up the strength of people of faith from being purged from the workplace without the employer providing them a reasonable accommodation. And the court even said, as I understand it, Kevin, that a reasonable accommodation isn't just coming up with one possible way of accommodating and then shooting it down. they need to look at all the possible ways to accommodate and find that none of them work and that they're all a substantial burden or cost, right?
Well, they need to look at, is there a substantial increase in the weight of the burden on the business itself, on the conduct of the business, not just any cost whatsoever. And so it's a big deal for employees who have a religious request. Now, that doesn't mean they will win every time, but it certainly has shifted the inertia on this significantly towards religious employees.
Right. Now, Kevin, we have not just one or two cases out there that could be impacted by this. We've got quite a few involving employees who were not reasonably accommodated because of their with regard to their faith and religious objection, right? We've got more than just one or two, right?
We've got over 90 across the country, from Hawaii to Florida to Seattle,
Yeah.
Boston, all over the place.
Yeah, and I know one of them alone, I think against the city of San Francisco, has about 1,000 employees. Just one case alone that we're representing, about 1,000 employees. So this is significant for us. I think it's impacting us in our litigation potentially more than anyone else out there in the country. That's just my personal gut opinion. I don't have it substantiated, but it's going to have a huge impact in our work and empowering us to have an impact moving forward. How broad is this, Emily, in terms of its real protection? Is it just for postal workers? Is it just for people who work for the government? Is it or is it broader beyond the government?
That's a great question, and I love, part of the reason I love this case is though it involves a government employee, but it applies to private and public employers. So you don't have to work for Uncle Sam or your state to have these protections. It applies in every state across the nation. And we know that many states have modeled, Nevada being one of those, modeled their state anti-discrimination protections exactly on Title VII. So you've got, this will actually, I think, impact those who are claiming state protections as well. And it is very broad. And if we didn't say this before, I just want to note this was a unanimous decision. And even on something as charged as this, the whole court said, no, de minimis is no good. Or as I think one headline put it, religious liberty gets the joy, being a joke on the name of the Postmaster General.
Yeah. Yeah. So this is a huge case, bottom line, folks, has a big impact on protecting people of faith with religious objections, wanting to be accommodated in multiple facets in both the private sector and the public sector. Huge game changer as far as we're concerned in defending religious freedom for people working across the country. It's a great decision. It's something that I've dreamed just to see, and there it was, unanimous. I mean, that's absolutely incredible. Now, Emily, I'd like you to talk about this other big impact case for religious freedom at 303 Creative LLC versus Elenis. What's this case about? It involves a graphic designer, right?
It does. It does involve a graphic web designer named Lori Smith, who for a number of years has had, I don't want to say a generic, but a business involved in creating websites for various entities, organizations, and individuals. And this lady, Lori Smith, wanted to expand into creating, customized, bespoke wedding websites. The thing couples do. You go to, emilyandsoandso.com and you can see your, unique, one of a kind wedding website. However, in Colorado, there is what's called a public accommodation law, and those are common in all the states. But this one made it specific that you can't refuse service to somebody based on a protected characteristic, and one of those characteristics is being homosexual or gay or being in a same-sex relationship. And so this woman, being a Christian woman, wanted to expand her business into bespoke, customized website design, but she could not, in good conscience, create websites that would celebrate and promote the same-sex marriages in Colorado. And so what she did was she went up and she asked for an injunction to stop Colorado from forcing her to create these websites or face fines and penalties for failure to comply with their public accommodation law. That's what she did.
Okay, So she took an action to try to get this corrected, so she's protected against this state statute and action. So she didn't prevail at the lower court, didn't prevail, I think, at the circuit court. So went to the Supreme Court. And what the Supreme Court, how they rule in this case?
The Supreme Court, to put it bluntly, said, look, public accommodation laws are important, but at the state level, but there is no public accommodation law at the state level that trumps your constitutionally protected rights, first and foremost among those being the First Amendment, number one, and that includes your right to free speech. So the state, in this case, Colorado, cannot compel you to speak or express a message that violates your religious beliefs or simply a message that you don't want to convey in the name of anti-discrimination. And I really want to highlight something here because I won't name outlets, but you can guess. We're very critical of this decision, which was 6-3 in favor of defending her free speech rights. They draw a very important distinction between service and message. And so the woman was very clear. She had no problem serving people and creating websites, regardless of their status, whatever your color, whatever your creed, no problem serving you. Her issue was being forced to create and speak a message that violated her beliefs. And so that's a big distinction here. Service with a smile, no problem, but you cannot force, compel, or otherwise punish someone into speaking a state-approved message.
Yeah, this is very broad because, frankly, when this came down, I thought, oh, we're going to deal with a free exercise case. It's going to be just focused on her sincerely held religious beliefs, free exercise. But instead, it looks like the decision was much more weighted on free speech, which is actually broader. And some of the case law they cited, like one was, the case law dealing with requiring a child to have to stand and give the Pledge of Allegiance. And the court in that case law said, no, you can't compel a child to give a Pledge of Allegiance that they don't really believe in. And I think it's because they were part of a religious group that what they did, that had objections to saying the Pledge of Allegiance. But it seems like this has some language that could be very beneficial beyond just certain occupations. It seems like the free speech language, we could even use this potentially in some cases where employees are being required to use certain pronouns that violate their faith, violate their conviction of right and wrong, and is, for all practical purposes to them, affirming a lie. What say you? Do you think this has that potential for application because of the breadth of the language, the free speech language?
I certainly think that is an argument that's going to be made, which is that the government cannot compel your speech. Now, of course, there are distinctions between an employment context and being a business owner. However, and here's another good fact to remember about this case, which is that one of the arguments made by the state was like, look, you're selling your speech. It's a commodity, right? So you forfeit. Basically, their contention was once you put your speech into the stream of commerce, you sacrifice your rights. And the Supreme Court said, no, of course we don't think that political speech writers can't be compelled to write what the government wants. That would be an interesting take on political speeches and debates. Jokes aside, that would be a very serious problem in a democracy.
Yeah, what about like colleges and universities, Kevin, where the university professor or the public high school teacher says, okay, I want everyone in the class to write a paper on why transgenders is a wonderful institution and should be encouraged and it should be supported by everyone. And you have a child who says, I don't agree with that. I don't agree that that's true, which the presupposition she wants me to state violates my convictions, or why the rainbow flag should be in every classroom. And some students say, hey, I don't believe in that. Could this language be helpful in that those kind of situations where we see growing attempts to intimidate students in public universities as well as public schools to say something or to write something that goes totally against their conscience?
If you're talking public, and let's keep this confined to the public schools, because you have government action. I think
Yes.
to your point, I like the line in the case that says that the First Amendment gives you freedom to think as you will and to speak as you think, and the notion that you could have have government orthodoxy of ideas is repugnant to our republic, or a constitutional republic, and I think it could cause problems. Now, of course, you have this is not, we're a little bit apples and oranges, because we're talking about a business versus a educational setting. But nonetheless, I still think that your point is well taken, that forcing a specific ideology on someone so that they have to parrot that is a constitutional problem.
Yeah, I agree. And so the case was dealing with a private business owner, but the potential application is much broader because it's the concept of free speech. And I love that quote you gave, Kevin, from the case. It's not just believing it, it's having to say something that is contrary to what you believe, or to say things that you agree with, and be able to be protected, to not to go against what you actually think. It's so important. We see so many growing attempts by government to silence, to censor, to issue controls. There was a recent decision from a judge in a circuit court in the Fifth Circuit who came out and said, the government has no business compelling and dictating, the FBI, the Department of Justice, CIA, whoever, telling private companies what they need to allow to be expressed or not expressed, like at Facebook, et cetera, Twitter. And it's a real serious issue in our country, this kind of Orwellian oppression. And so this case law is very timely. It's very broad. It's very helpful. And I see it having a tremendous impact across multiple dimensions, but especially, of course, for business owners. We at PGI do a lot of work defending business owners, folks. And if you want more information on your rights as a business owner to live and share your faith with your customers, your community, your employees, you can get a look at this for free at our website, pji.org, and just click where it says businesses or business, or clicks that, and then look at our resources and you'll find it. It's very, very helpful. Okay, if you want to ask questions, what I encourage you to do is to put your questions where it says Q&A down at the bottom of the screen, not with chats, because we're not going to see that. I want you to put it where at the bottom of the screen you'll see Q&A. Down there you'll see security, participants, then Q&A, and then some other things. Q&A is what you want. So we just opened it up, and go ahead and put your questions there. If you already put your questions under chat, just try now to put the questions under Q&A. This helps us see the questions real clearly, so we don't have to sift through just all the comments. And they are popping up. Excellent. Let's start first with, let's see, here's the first question. I live in Portland. Many churches here do not talk about what is going on in the government. I have visited several of them. One church leader actually said he does not get into politics. We need a lot of help here in Portland. Oh, I've seen this before. That pastor needs to read Ezekiel 3:18 and 19. To paraphrase, basically what it says is, if you do not warn the wicked of their wicked ways, that they might turn from their iniquities, the wicked will suffer, but their blood I'll require at your hand. The bottom line is, and it deals with both the wicked and the righteous as far as reproving, God holds us accountable. And if we know the word and the Bible, we know the truth. And pastors, if you know that and you're keeping it because you don't want to offend someone, then you're being a pleaser of man, not a pleaser of God. And I encourage you to try to find a church that you can go to that's not going to fall into that. There's some great churches, evangelical churches out there, Calvary chapels, Baptist churches, and others, and just keep looking to find one that doesn't skirt around scriptures to not offend people. The Bible is very applicable. It's living, it's active, it's sharper than a two-edged sword. It applies to the issues of the day. And the issues of the day often are political because they're impacting us. And that's what happens when you have issues impacting people. They become political. Well, we need to address those, just like the Apostle Paul didn't hesitate to address the issues of the day in dealing with the church of the Corinthian church or other churches. So that's my 1-2 on that one. But I encourage you to definitely not be discouraged. It says, are churches allowed to harvest ballots after a church service? Are they allowed to harvest ballots after a church service? Well, let me just say, it depends on the state that you're in. Kevin or Emily, would you like to comment on that with regards to any states that you know of offhand?
Yeah, you hit the nail on the head. There is specific state laws, and you'll need to check those on that, whether on drop boxes and that sort of thing, what you can do.
Right.
Yeah, I'll just,
go ahead.
I was just going to add, here in Nevada, we are unique in that we allow ballot harvesting, and we have no limit on the number of ballots you can harvest. So various organizations are quite active, and I would love for our churches to be equally active, because unlike even California, here in Nevada, it is no hold'em, something poker reference. I'm not a gambler, but I will put that out there. And then I just wanted to also add, there is a great free resource on our website. So if you go to www.pji.org, there's a great free resource called The Church and Politics, which addresses both, can tie into this question and the last one. And it can, I think, offer a lot of legal reassurance to pastors who maybe are, worried about talking about politics. I know there's a lot of helpful legal information in there as well.
Yeah, thank you for mentioning that. It's a great resource. And pastors are free to talk about the issues every Sunday if they want. They could talk about abortion if they wanted. There's no limit on the issues. They can talk about legislation, being in support of legislation, opposed to legislation. I know there's two bills in California, AB 665 and AB 957, that are horrific, are going to allow children to be taken from families just because of the Christian beliefs that families have with regards to gender identity confusion, and not wanting to encourage that confusion. They could potentially lose their children just for that, and be taken by a healthcare worker without due process. It's horrific. It already passed the state assembly. It's now before the state senate in California, both of those bills. So that's just a classic example. I would like to see more pastors talk about these, mention these, because what's going to happen is a lot of people in California are going to pick up and leave the state, and leave other blue states that adopt similar legislation and move to freedom-loving states that aren't going to take their children late at night or while in a public school just because of the Christian beliefs of the parents. That is where we are, though, folks. It sounds like I'm talking about something from, some part in history in some other faraway country. This is where we are, and that's why we at PJI, I think, have exploded so much and have so many cases, because our goal is to make sure that everyone gets help, that no one is left on the side of the road. We don't just cherry pick a few high-profile cases like other organizations do. We are very unique. We work hard to make sure that everyone gets help, and these cases are just exploding as we speak. Okay, next question. What about this affirmative action that the Supreme Court just decided? I'll just give you just a real brief overview on that case. Basically, what the court said is that the government, in this case, we're dealing with actually University of North Carolina and Harvard University. They cannot discriminate based on race in terms of admissions. That's what the Equal Protection Clause says, the 14th Amendment Equal Protection Clause. It's very clear, and so if a university, like the University of North Carolina, it's a government institution that falls under that language of the 14th Amendment, and then that same language comes through Title VI, which applies to Harvard and in universities and things like that. And so so bottom line, that's going to impact not only college universities, but also companies that have any contracts or receiving government money from the government. They're also going to be prevented because of this from discriminating based on race or ethnicity, national origin. It's a very, very significant decision in that regard. And that's all I can say there. But I think that employers out there need to be extra careful. Companies, large companies that are in any way working with the government and with programs with the government, and they're real big on the ESG. A lot of that is promoting discrimination, race-based discrimination. They're going to be sitting targets, and there's going to be law firms out there that specialize in this area that are going to be targeting them moving forward, I'm sure. So that's about all I can say on that one, but very, very significant case from a civil rights perspective and equality perspective. California is passing demonic bills faster than we can oppose them. Is there any way to reverse or undo these bills? Well, yeah, well, two things. First is we can elect people to the legislature to undo those bills. That's one way. Right now in California, those who have a biblical worldview are grotesquely outnumbered by those who have a worldly or demonic worldview, if you will. So that's number one. Number two is to litigate. And we at Pacific Justice, we fight these cases actually before they become law. We send legal demand letters. Matt McReynolds, one of our star writers, an opposing legislation for our Center for Public Policy. We've seen bills defeated before they were even voted on because we showed how they were clearly unconstitutional and how the government was going to lose. That sometimes works, but when it doesn't, then we have to litigate. And we've done that before. Kevin Snider has taken cases on behalf of California in particular. I know more than one that went to Supreme Court, and we weighed in on it very heavily and saw some great outcome. So, but it takes a lot of work, and it means more work, and that's one reason why we have a new legislative council to also help on the offense with red states to pass positive laws, and those are happening incredibly for the sanctity of human life, for parental rights, for religious freedom. It's a heyday. I just testified recently in Texas state legislature about 2 months ago in favor of school chaplains, funded school chaplains. They pay for school counselors, also pay for school chaplains. It passed, signed into law. In fact, they got more than 2/3 majority in the state legislature. I felt like I'm in California. I feel like I'm in the 7-year tribulation. I go to Texas. I feel like I'm in the millennial, and it's night and day. Well, we're taking advantage of those opportunities now in the red states very aggressively at the same time while we're fighting these things in the blue states. Good question. Next one is right there. Hi, Brad. As a result of these Supreme Court cases, do you see this providing some strong leverage in many of your existing lawsuits to reach a faster conclusion or settlement? Very good question. Kevin, what say you?
Yeah, I think that this does help us. It gives us more leverage on things. Whether or not any given case will settle quickly because of this, it depends on the facts. Did the employer rely on this de minimis standard, or was there some other reason for that? But to the extent that they were relying on that, then we think this really improves our chances.
Yeah, we have so many cases that were directly impacted by that postal worker case, the golf case. It's not like we're like, okay, now we're going to start filing lawsuits. We already have the lawsuits filed. We've already had the deposition. We've been in full steam litigation, and the cases are actually increasing, not decreasing, for us as we speak. So we're moving gangbusters, and we're hopeful, as like you said, Kevin, that we're going to get some of these cases settled sooner because of it. Our goal at PJI is to put the client first, and if we get the case settled to meet the interests of a client, so they can move on, all the better. If not, we'll take a case as far and as long as we need to without charge, all the way to Supreme Court, and we have a good number of them pointed in that direction, and we're willing to follow through on every single one of them if we need to. And I just want to thank you out there who are supporting our work right now, because our litigation and the demands on litigation has never been more intense. We've got places where cases are just flowing in more than the immediate attorney can handle. So we're trying to bring in more legal staff. Please pray for us, but also please remember the value of your support and being a part of our team here at PJI. It is not taken for granted at all, and it's extremely significant, I believe, right now, where God has given us this great opportunity to make real progress. Here we have I'm a high school teacher in California. My district and many of my colleagues are very woke. How do I provide a voice for my conservative students? Emily, any thoughts on that?
That's a great question. It depends on how you're looking to provide a voice. For example, PGI has been I want to say we have a perfect track record. Please correct me if I'm wrong, but I believe we have a perfect track record when it comes to supporting the formation of Christian clubs. So if students are looking on their own initiative to set up a Christian club or a Bible club or a conservative club, or all of the above, there's a great case precedent for that, and we're always happy to write a very effective letter to support that. So that's, I think, a very easy step one. Not easy, I shouldn't say that, but something that we were very successful in supporting students and teachers in doing that. So that is an immediate way that you can support the students, and also encouraging students and parents to speak at the school board meetings. You know, I watch the local news, I watch the national news, and people listen very carefully when you have students speaking to the school boards. And a lot of local school boards actually have student representative positions. And although I would say various groups like to stack those voices to lean a certain way, I think it is another way that you can get students directly involved in representing their peers.
Yes, yeah, very good. Someone asked for me to repeat the reference I gave. I guess it's about the scripture about our need to warn others and not to be silent. That was Ezekiel 3:18 and 19, chapter 3, verses 18 and 19. So yeah, good question. How might these rulings impact the average Christian in the workplace who receives pressure to use pronouns or other woke policies that violate his or her religious beliefs? As we mentioned before, this is some case law that dealing with the free speech in particular, I think could be very helpful. As far as on the accommodation side, the other case will be helpful dealing with the postal worker for the employee rights. So there, I think both of these cases could be cited in the same legal brief, dealing with an issue of an employee being required to use pronouns or lose their job or woke policies. The key here is for you to, number one, be aware of what's going on. So if you're not getting our case updates, get our case updates, because that's where you know where you are, where you stand. It's our legal insider. Just go to pji.org, or you can text PJI to the number 71541. That's number one. Number two is contact us sooner rather than later. So if you start having an issue, any kind of conflict, any kind of uncertainty, don't wait until you're fired to contact us. Contact us if you're fired, but don't wait. If you can, contact us as soon as possible so we can empower you as to what your rights are. And we've got some great material and articles on our website to help as well regarding that. If AB 1078 passes in California, would school board members and superintendents have standing to sue the state over chilling of speech rights due to the threat of fiscal punishment to the district, as well as publication of names of superintendents and school board members who don't adopt books the California pushed by the California Department of Education? That's a really good question. Kevin, Emily, what say you?
So and what they're referring to is a bill that restricts the type, essentially gives the state veto power over the types of curriculum and library books that a school district can have. And the idea is to prevent the removal of books that are not age appropriate, that have adults or conduct or content. And so that's it's possible that a school district would have standing. Whether or not they would be successful, I don't know. It's something that would could go either way on that. One of the reasons is, on the one hand, the school district would say that the state is trying to censor the school, and on the other hand, the state would probably say that the school district is engaged in censorship. So it would be a balancing test that who knows how it would turn out.
Okay, yeah, good point. Another question.
Brad,
Yes.
Brad, I was just going to add, Matt McReynolds wrote an outstanding letter of opposition to that is available for public distribution if anybody wants a copy of that.
Yeah, thank you. I appreciate that. Yeah, we have a strong arm when it comes to legislation like that. We weigh in heavily, and that's why sometimes we're able to defeat it before it even comes up for a vote. We show the ludicrousy of it or the unconstitutionality of it. And Matt is one of our star legal brief writers and or legal opinion review critic writers. So I encourage people to do that. pji.org, great place to look. We put out high quality product that definitely gets the attention of legislators when we weigh in. Now, someone says here, they say they want to support students by opening a Christian club. Their school that they have a wellness meditation room, but they're not allowing the Christian club because they said it's too offensive to other people. We have a book on this called Reclaim Your School. It talks all about all the different ways you can evangelize public schools, what students can do, teachers, ministers, school board members, etc., parents. But in short answer to that, I'm just going to say that we have this protection, statutory protection, the Equal Access Act, that is there to protect Christian clubs to be given the same opportunities as other clubs. Matt or Kevin, do you want to say anything in addition to that?
No, I think the best way to approach this is again through the school clubs, and because they have special federal protections to give them equal footing with others. Yeah,
and back my wife and I, we worked with our church to start a Christian club at local high school and a public high school, and through that Christian club put on a full-blown revival rally in the middle of the quad of campus of this public high school, just to show how far things can be pushed through the power of this federal statute. So I encourage people to take advantage of that moving forward. Great opportunity. And that book can be downloaded for free at pji.org. Next question. Why are these legislations allowing minors to be removed under the misinformation that parents protecting them from bodily harm that violate the First Amendment of our Constitution is not an automatic lawsuit? It is a violation of parents' rights as well as freedom of religion. Absolutely. I agree 100%. And that's why we have gone to court more than once to protect children who are taken from their parents for the purpose of cutting off body parts, injecting them with hormones, and trying to, quote, change their gender, which is actually impossible. You can't change the DNA of every cell in a person's body, which is very definitive of their gender. But that we've seen that. We've had to go into court, and because we were contacted, we were on more than one occasion able to save that child and have that child given back to their Christian family, they were taken because the parents were Christians. Not once, not twice, actually 3 times I can think of right off the bat, we've had to intervene in something like that. So even if this doesn't pass, it's still happening. We still have social workers and their state agencies up and down the state doing this. It's not just in California, it's also in other states as well. We believe it is unconstitutional. So if you know of anyone that's dealing with this, have them let us know immediately. And this is the kind of thing that we can challenge as unconstitutional. I think we can set some great case law in the process as well. Get a case like this before the Supreme Court. I'm pretty optimistic. I think that I know what the outcome would be, especially with our fine attorneys and how they do such great preparation for our litigation, our cases. Can you comment on the sweet cakes? No, is that one, or actually no? That's the next one. Okay. Yeah, actually the sweet cakes, I'm going to comment on that one. I think it's one out of Portland. And the Supreme Court, I understand when they came down with the decision dealing with the website graphic designer, they said, oh, and by the way, we're sending this back down to Oregon. It's in Oregon. We're sending this back down, and please rehear this case in view of our decision for religious freedom in this 303 LLC case. Do you guys have anything else to add to that?
Kevin, well, that's right. It's a public accommodation law out of Oregon that was mirroring the public accommodation law at issue in Colorado. The creative message being, in pastry form rather than website form. Yeah,
very well put. Well put. And yeah, very good. My wife is a radio announcer at a public radio station and is being forced to promote Pride Month on her show. Do any of these decisions affect her ability to refuse to do this? It's interesting because, mind you, the Supreme Court didn't give an absolute mandatory requirement for accommodation at any price for someone with a religious objection. The employer has to show, though, there's an undue burden or hardship on the employer to engage in that kind of accommodation. So, if she is the host how would she be accommodated in a way that would not create undue burden and hardship on the employer? Any thoughts on that, Kevin or Emily?
Yeah, we've had that situation a couple of times. One time they were able to switch and have someone else, another announcer, do that. Other time it got a little more tight. The employer didn't want to back in, want to back down on that. So you're in a tight spot when you're when your voice is the medium of communication for the job, and they're giving you a specific script. So it's not the easiest of cases, to be honest with you.
Yeah. So that's what we have to do. We have to call it like it is, and we work hard to do that. So hopefully this has been very helpful. I notice there's still some more questions out there, folks. So what I encourage you to do is we'll answer your questions. Just go to our website, pji.org. In fact, we even have a chat on our website that you can participate in on our website. Give us your questions, and we can try to get back with you. It may take some time. May have to do some research, but it's pji.org, pji.org. The good news here, folks, is we have got the big picture is in the last 2 years, we've seen great case law set because of 3 justices that were appointed by former President Donald Trump after being elected in 2016. I mean, that's what we're looking at. That's how critical things were in that 2016 election. We're seeing the fruits of those appointments as we speak in terms of sanctity of human life. Thousands and thousands of babies have already had their lives saved. Countless numbers of kids are going to be going into Christian schools in safe red states, freedom-loving states in particular. And then the religious freedom in the workplace, religious freedom for business owners, free speech rights. This is an exciting time. And I just encourage you, want to be, oftentimes we look at our society and say, we're going down the drain, everything's going downhill. Sometimes it can seem like that, but in reality, God is giving us a second wind, if you will, of opportunity. That may be where we are today. Read the book of Esther. It's not that long. It's just like 9 chapters. I preached on it, like I say, last Sunday. And as far as I'm concerned, we may be in another scenario where the darkest of the darkest is actually just ahead of one of the brightest dawns of great opportunity. And I see that opportunity coming. And we at PJI want to be faithful with that. And thank you again to all of you who choose to support our work. If you're supporting us on a monthly basis, double thanks. You can do that on our website, pji.org, pji.org. And once again, if you haven't signed up for our Celebration of Justice, October 28th, you can do that on our website, pji.org, pji.org. So folks, no matter what we're going through, no matter what the trial, no matter what the challenge, always, always keep the faith.